Okay. We don't have all of our members joined just yet, but I'm going to go ahead and hold on. Okay, let's go ahead. Can you all hear me? Okay, I'm going to go ahead with roll call. So Marla McDade Williams, I'm here. Terry Kearns.
Present.
Mark McBride.
Present.
Scott Killebrew. Senator Rochelle Wynn. Lieutenant Diane Goldstein.
Present.
Assemblyman Max Carter.
Present.
Assemblywoman Danielle Gallant. I'm sorry, did you say present? Are you here? Jonathan Dalton.
Present.
Dr. Majib Shad. Burton Tabak.
Here.
Dustin Hines.
Present.
Catherine Cotter.
Present.
Joshua Garber. I see you. Is your audio working? All right, I'm marking you present because I see you, but I didn't hear your audio. So John Oseguera.
Here.
Okay, just to go back over this, Scott Killebrew. Senator Rochelle Wynn.
Here.
And Assemblywoman Danielle Gallant. We have a quorum. Thank you all. I'm hoping this is the last meeting for the working group on psychedelic medicines. And at this time, I'd like to go to public comment. To provide public comment telephonically, dial 1-775-321-6111. When prompted to provide the conference ID, enter 172-799-042#. If providing public comment during the Teams meeting, unmute your microphone prior to speaking. Persons making comment will be asked to begin by stating their name for the record and to spell their last name. If you are on video, if you would like to give public comment, please raise your hand. I'm not seeing anything. Is there anyone on the phone who would like to make public comment? Emily, are you trying to speak? I can see your audio, but I'm not hearing anything. Okay, I'm not hearing any public comment. Then we will move on to our agenda item 4, approval of the June 25th and September 6th meeting minutes. Are there any comments on the minutes?
I have a couple just brief comments, if that's okay. So
Go
I
ahead.
think some of the science really got mislaid. And this was some of the science by Dr. Shaw talking about toxicity. And so I was trying to lead with some Socratic questions. Brian Lang later kind of corrected this too. So I think the record shouldn't reflect misinformation. It does. We should correct that. I don't know how to go about that because Dr. Shaw did obviously say those things. But if you see on page 5 and 6 where I'm trying to lead the dialogue and say, is there evidence for this? What about PK? And later in that session, Dr. Lang kind of picked up on that and said, look, we've given pounds of this to animals and nobody's ever gotten really sick. So I don't know how to correct that, but it's scientifically not correct the way the record is right now.
And can you clarify again for me? So did you say it's what he said, but it's not correct, or?
He claimed that psilocybin is toxic. And so then I asked in the record on the topic, well, what metric is that? Is this PK and ADME, which are pharmacokinetic metrics that we use to say that something's toxic? He didn't respond to that. I said, well, I'd like to see the evidence for that because there is none. And then Dr. Lang later speaks up and says, you know, people have tried to run a couple of experiments to see what the lethal dose of this is, and it's not even fathomable how high it is. So I think the record should reflect facts and not misinformation. And I could send you some jargon for that in the email, or you could quote Brian Lang where he corrects the record later on.
Marla, can I respond?
Yes.
Yeah. So I apologize for if you misunderstood. I never said psilocybin is toxic. Somebody asked me the higher dosages and trip dosages. You know, there is much less data for its safety. That's what I was talking about. And the micro dosages are completely safe, as has been shown by multiple studies. So I don't know what else you want to know about this.
So I will take that correction and add it in. You know, I'll review this and see about that claim, and I will fix it in the minutes. Are there any additional comments?
Yeah,
Mark McBride for the record. I believe that conversation back and forth should stay in the minutes, even if it's still being looked at. It shouldn't be deleted out.
Yeah, and I totally agree with that. It'd just be adding, number one, maybe a scientific reference rather than just people talking that show the facts, because the facts are there. And then also maybe Brian Lang's comment with citing the actual paper, which I can supply to everyone, showing that it's not toxic.
Okay, so we'll make that addition to the minutes. Any other comments?
Yeah, this is John Dalton for the record. On June 25th, the June 25th draft minute states various links posted in the chat for reference and additional questions. And I'm just asking again if we can, as the working group, if we can access that chat history because of all the data that was in that in the chat links.
I will have to look at that. Generally, chat is not part of the meeting record. I will look at it, and chat is turned off for this meeting. If anyone has public comment that they want to give, they should give it during the public comment section. So I'll reiterate that. But I will go back and look at and whether or not we can pull up the chat for this particular meeting. And see if there's a role to maybe include it as an attachment and a reference in this meeting agenda.
Great. Yeah, you should be able to. Usually with Teams, you can access the earlier meetings. In fact, I can access
sometimes it expires. So
yeah, I
in our
can still
system,
see
sometimes it expires.
Yeah, I'm still talking, but I can see that I can still access it, but since I'm external to the group and I would need you to accept me, I can't. So yeah, you should. Yeah, just if you could, I'd really appreciate it. Thank you.
Thank you. Any additional comments?
Yeah, Diane Goldstein. I think the importance of kind of the research and as we note about attachments to the minutes, it's also about, and I know we're going to discuss this more on the discussion of the draft report and agenda, is I think we need to also make certain that the research is properly cited, whether it's in the minutes or in the draft report. And that's just a comment relative to these issues, because this is a very, very complex issue.
Thank you. Any additional comments? So with those revisions as noted, can I get a motion to approve the minutes?
This is Terry
Can I
Kearns
ask
for the
a question,
record.
Marla? Oh, I'm sorry.
If I can get a second, then we can have it in discussion.
Mark McBride, I second that.
Okay, and discussion?
Are we having another meeting regarding this? Because I don't particularly feel comfortable voting on minutes that are conceptual, that we haven't been able to see how they have changed.
The plan
agree
was
with
that this
that.
was going to be our last meeting. But I'm happy to hold another meeting if that's the group's preference. We are under a deadline to get, the report back to the legislature. And as you know, I have another job. And so this has really been challenging for me to pull together. But if that's the preference of the committee, then I'm happy to do that.
Well, I know that there's a motion that's before us. I'm inclined to vote no on that motion and then later on ask for another meeting.
Thank you. Any other discussion?
Just to add on to what Senator Wynn said, I did notice when I was trying to review the draft report, I was also reviewing draft minutes. And so therefore I found it really difficult because they weren't complete minutes.
So that was that.
I think somebody might be unmuted.
Yeah, I'm sorry. We got an echo in the room again, and I'm trying to resolve that. So I think we're good. So I appreciate that comment. So any other discussion? All right. All those in favor of approving the minutes?
Aye.
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 And all those opposed?
Nay.
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 Nay. Nay.
Nay.
Nay.
All right. So the approval of the minutes has failed, and we will talk about having another meeting to approve those minutes later on in the agenda. Agenda item, let me get to the agenda here. So we are at agenda item 5. And this is Lori Bratton with the Program Director for the Natural Medicine Board, Colorado Department of Regulatory Agencies, presenting on Colorado's enabling legislation and rules development process related to that state's Natural Medicine Health Act. So I am going to attempt to share her screen. And then she can begin as soon as I can get this handled here. Okay, Lori, go ahead.
Thank you so very much. And it's nice to see you all this morning. I'm Lori Bratton. I'm the program director for the Natural Medicine program here at DORA, which is the Department of Regulatory Agencies, and it's the state's umbrella regulatory agency charged with with managing, licensing, and registration for multiple professions and businesses. And I sit under the Division of Professions and Occupations, which is in the Department of Regulatory Agencies, and we provide consumer protection through regulation of more than 500,000 licenses within 50 professions, occupations, and businesses in the state of Colorado. So that being said, the natural medicine program is pretty new. In 2022, Proposition 122, referred to as the Natural Medicine Health Act of 2022, was a citizen-initiated measure related to the use of certain plants or fungi for people 21 years of age or older. The act received approval from Colorado voters in the November 2022 Colorado general election with the 53.6% of the vote. So, next slide. What the act did was it really decriminalized cultivation, possession, and personal use of natural medicines for individuals over 21. It directed DORA to establish regulated access programs for natural medicines. So for supervised administration of natural medicine, and to create implement the licensing structure and the framework for regulating the growth, distribution, and sale of natural medicines to licensed entities. It also established the Natural Medicine Advisory Board for the purpose of advising DORA on the implementation of the regulated access program. The act also allowed it, Proposition 122 permits that individuals and local municipalities are able to regulate only the time, place, and manner of operation of healing centers. And it also sealed criminal records of individuals who had completed a sentence for a conviction that's no longer considered a crime pursuant to the legislation. And it protects conduct permitted by the Natural Medicine Health Act by itself for preventing, punishing, or penalizing individuals that are on parole, probation, so forth, or disqualifying individuals from medical care, medical insurance, or to deny eligibility for any public assistance unless required by public law. So there are several types of natural medicine that are included in the act, which is DMT, ibogaine, mescaline, which excludes Lophoria wilsonii, which is peyote, psilocybin, or psilocin. And as of now and until June 1st, 2026, natural medicine is specifically only psilocybin or psilocin. After June 1st, 2026, and if recommended by both the working group and the advisory board, the department can determine if we will be including some of the other natural medicines in and folding them into the regulatory model and including them as considered natural medicine for regulation. The regulation from 122, regulation for licensed facilitation services and cultivation, the manufacturing, transportation, possession, distribution, handling, all of that fell up to the Division of Professions and Occupations, to DORA. So as I mentioned earlier, DORA has oversight of professional licenses, not facilities. So move on to 23290, the next slide. So later on in 2023, there was a Senate bill that was introduced that basically was to clean up the measures that were in the act. And since DORA does not regulate facilities, does not regulate the manufacturing and distribution, that Senate Bill 23290, which is the next slide, Marla, was put in place for a lot of clarifying of this original act. So it allowed the natural medicine program to create the facilitating licenses and to manage the act of facilitation, but it was modified so that the Department of Revenue had oversight of manufacturing, cultivation, and also extended our deadlines, which was originally September of 2024 to December 31st, 2024. So DORA's responsibilities continued for licensing and regulating of facilitators, and then it added the following duties to DORA, which is to establish the federally recognized tribes and indigenous community working group and the advisory board and the annual reporting in coordination with the Department of Revenue. So again, the Department of Revenue is responsible for licensing and regulating healing centers, cultivations, manufacturers, testing facilities, and they have a new natural medicine division. And they are assigned with all of the things I just mentioned, including public education campaigns, some types of data collection, which is narrow in the data collection that they are assigned, which is adverse health events and incidents. They have also been tasked with providing training materials for first responders, and the testing and the certification piece of all of this went to the CDPHE, which is a Department of Health. Senate Bill 23290 also had some personal use provisions. So it allowed personal use of the natural medicines listed, the psilocybin, psilocin, ibogaine, mescaline, and DMT. It allows for personal cultivation, not more than a 12 by 12 foot a space and a private property that's enclosed and locked. And it also allows adults to share with other adults that product if they are 21 or above, and they can share that in the context of counseling, spiritual guidance, and community-based supported use or related services. There's no remuneration except for what's allowed at bona fide harm reduction or support services right now. There are also no advertisement related to sharing or services, and persons sharing must inform the participants that they are not a licensed facilitator. There's also no manufacturing allowed that combines inherently dangerous substances with the growth and cultivating of the mushrooms. Nor is there open public display or consumption allowed. It also established offenses for violations. So we drafted after the advisory board was created. I think it's the next slide. Yes. So we had the advisory board created from the governor in early 2023, and actually before Senate Bill 23290 was signed, the advisory board had already began meeting. So they set out to do the work tasks within the mandate. They had, of course, we had specific backgrounds and experience that the advisory board members needed to have. So we had 7 members with these healthcare, public health, mental and behavioral health providers, emergency services, permitted organization, mycology, cultivation, and natural medicine therapy, and 8 members who are additionally from various areas of expertise also. So from the board's establishment, we formed subcommittee groups. These subcommittee groups met over a period of a year in excess of 80 times, 3, 4, 5-hour meetings. They met to discuss the requirements from the statute that said that they needed to determine the qualifications for licensing and training. They needed to meet in regards to products, research, data. And we had an emergency response, safety and ethics committee, and an indigenous and religious use and outreach, and a public health and health equity committee. They spent hundreds and hundreds of hours devising recommendation, hearing from community experts, and using their own expertise to come together and make recommendations. Oh, here are the other 8. I apologize. The 8 members that had other significant experience. So the subcommittee met up until they met with, including the full board, all the way through January of 2024. And they delivered over 66 pages of recommendations to the Department of Revenue, which a lot of the products recommendations and the health and safety recommendations were very specific for the Department of Revenue. Of course, the licensing criteria was very specific to DORA. And so those recommendations were finalized and delivered in January to the division directors. And we began the work towards rulemaking. So we took all of the recommendations that they had made, and our task was set forth for us to actually develop rules. Now, before I talk about the rules, I wanted to share with you one of the things that 23-290 also required was for the director to form a tribal working group. So the federally recognized American Tribes and Indigenous Community Working Group. I know it's a very long name. We had 47 applicants. 9 members were decided on. 7 of those are from federally recognized tribes, and 2 members who are Indigenous but are not members of federally recognized tribes. And here are the members listed. I'll provide this PowerPoint to Marla if you all are interested in it. The working group was established for the purpose of engaging and creating a dialogue to identify issues related to the commercialization of natural medicine product, and natural medicine services for the tribal and Indigenous people, communities, cultures, and religious. The working group was set out to study avoiding misappropriation, exploitation, avoiding excess commercialization, and any conservation issues, and also best practices that promote open communication and build trust and understanding between the government and the working group. That working group was formed, and they had their first meeting in May of this year, and they are about 5 meetings in, I believe, and are starting to work on their report. They will develop this report over the topics that they're mandated to study, and they will provide that report to the working group in early 2025, or provide that report to the advisory board. And then the advisory board will then make further recommendations based on that, as far as to whether or not we're going to update rules. Possibly we will just receive a lot of best practice information. And we're really looking forward to the work that they're doing. Now, there was a slide back on SB 198, so I wanted to quickly go over 24-198, which happened earlier this year, and that we were tasked with developing not only the licensing structure, but DORA was tasked with approving training programs. So the training and education that facilitators would have. So we had Senate Bill 198, which authorized the director of the Division of Professions and Occupations to actually approve training programs. So we didn't fully have that authority. It wasn't very clear in the previous legislation. So this bill came along to actually clarify that and allow us to approve training programs. So now I'll talk about a little bit about our rulemaking. As I mentioned before, in the beginning of the year, we took all of the advisory board's recommendations, and our board is an advisory board. So their role is to make recommendations to the director. Those recommendations, there was hundreds of recommendations when broken down. And we did our very best to create a set of rules that was true to their recommendations and still following DORA or DPO's internal kind of processes that we do for creating licensing structures, applications, and so forth. And I think that we have done a wonderful job. The first set of rules was totally effective on September 14th. We had the first section in June of 2024 that was approved, that gave us the ability to get going on creating applications for the training programs. We did that, and we actually have had 10 applicants. 8 training programs have been approved to provide education. We wanted the education piece to begin so that by the end of the year, we're tasked with opening up the actual license applications for facilitators, and those facilitators, of course, need training. So we started with our rulemaking, developing the rules for the training program and the licensing criteria, and those were effective in June, the beginning of June, and the remaining part of the rules, which covers disciplinary action and standards of care, was effective in September. So we are actually back in rulemaking right now to provide clarification. Of course, as you implement, you find that you need to do more. You need to clean up verbiage and so forth, and we're doing that now. And our applications are set to be open at the end of the year. We're on target for that. And the Department of Revenue is developing their applications for healing centers, manufacturers, and cultivators, and they have the same deadline. And so early next spring, we should be on our way to implementing. I will add that DPO also does the enforcement piece of oversight as far as professional licenses. And so individuals in the community who have a complaint will also submit those complaints against a licensee through DPO, and we initiate the enforcement process, the disciplinary action for facilitators. Their Department of Revenue has a similar process. Well, they will do the enforcement actions for facilities. So all of our rules and information is located on the dpo.colorado.gov natural medicine website. So I encourage you to review the information there so you can see the massive amount of work that has gone into creating these rules. We're very excited about where we are now and about Colorado moving forward with what we think is a unique and different approach than Oregon's approach, which we've included in our licensing structure, the ability for professionals, medical professionals, and mental health professionals to obtain a clinical license so that they can, in combination with their mental health license or their medical license, do facilitation, which the evidence shows that in psilocybin, natural medicines particularly, is extremely helpful for various mental health conditions, and that these practitioners will be able to incorporate their already massive amount of knowledge regarding mental health, and combined that with their facilitation, add another tool in their toolbox to support their patients and with the medicines. So I'm happy to answer any questions. Like I said, we are still in the process of implementing, and we'll be live at the end of the year, but our training programs are up, and I would be entertaining any questions you may have.
Thank you so much for your presentation. Are there any questions, Dr. Shad?
Yeah. Really exciting work you guys have been doing, and I'm glad that you recognize some of the issues with the Oregon implemented program. My question was that, are you also making sure that the clinics which are authorized to do this based on your rules and regulations, are you going to make sure that they have experienced psychotherapists and trained psychotherapists to do this?
Well, there are two types of licenses. The first license is a facilitator, which would have no medical background or training. And those individuals do have the ability, when they've completed their educational coursework and their practicum coursework, to do facilitation. So the other avenue of licensure is the clinical facilitator, which is those who have, secondary licensure. So the healing centers, those who open healing centers, some of them are going to come from our training programs, who will actually train in a healing center. Others, we're not sure what to expect in the spring, and we're not sure how they will staff them. And it makes perfect sense that there will be people there that are experts in integration and in psychotherapy and so forth, but that's a little ways off, so we're not sure how that will look.
Thank you.
Are there any other questions?
I do have a question, if that's okay. Do you have a list of the approved training programs by any chance?
Yes, we do. It is on our website. It's listed right on the front page. There's a little blue tab at the bottom, and then it lists which programs have been approved.
Great, an excellent presentation. Thank you so much, Lori.
Thank you.
Senator Nguyen?
Kind of in line with what Kate had asked, that list of like training programs, how long did it take to get those up? Are they all local? Do you have other people from other states coming in and doing that training program? Do you know many of those details?
Oh, yes. The training programs are what we have been working on, their applications this last summer, and setting the criteria for the training programs, which are outlined in the rules. We do have, I think, 4 or 5 training programs that are also licensed training programs, are certified in Oregon. So they have expanded. We have more stringent requirements for the curriculum. And so they'll have some additional work if a facilitator has received training in Oregon from one of the approved training programs there, they can finish up their added requirements that Colorado has, and then seek licensure in Colorado. The training programs in Oregon, they're very verse in both the Oregon and the Colorado, and they've been wonderful to work with to adapt their curriculum to the Colorado requirements. And we do have a few that are just Colorado based, and they are going to be launching their training more in 2025. The Oregon based programs are able to do some of that legwork now in advance because they're licensed already in Oregon, or they're established in Oregon. So we have a mix of both.
And may I follow up just on the costs? Like, do you know what the average costs are for this training?
Well, I can speak to what I see on their websites, and their websites are saying for the 150 hours or more, many of them offer a 200-hour program or something much more. It is anywhere between $5,000 and $10,000. Some of them include their practicum, consultation requirements, a variety of things. Now there is a smaller 25-hour module that is required for Colorado, that if they already hold a license, they're going to need to get a licensee will need to take that one course. Of course, that is going to be much less expensive, but I haven't seen the cost for that listed yet.
Hi,
Thank
Lori.
you, yes, Dr. Hines.
Thank you so much for your presentation. And again, I love organization. It makes my brain very happy, and I can see how organized and thoughtful this program is. Within that, I can see you've already started to build metrics and other things into the program. What are some of the key metrics you're looking for to come in and grow so you can understand how things are going?
Well, one thing that I will say is, regarding data collection specifically, we were not mandated. DORA was not mandated for any data collection, actually, and the Department of Revenue was mandated to collect data on adverse events and first responder type events. And while one thing we would love to know more about is the numbers, we absolutely want how many, we want to know the outcomes. It is a hot topic now amongst the advisory board and the community and people who want to be involved in data collection and research and science. So that is the thing that we feel that we've got to do something about. We have to, and we're looking for a variety of ways because we did not have physical allocation for that fiscal allocation, or we did not have a mandate to do that. So that will require legislation if that were to take place, but maybe there's some other ways. And we developed a subcommittee, a forms subcommittee. The advisory board, a few of the members got together and from the rules, they said that they wanted to document, create the actual documents, the forms that they believe facilitators should use, and that when there is a data collection registry or something that comes online, that the data will be there. And our rules do require facilitators to maintain the data, demographic information, dosage information, all of that's outlined in the rules, and they will hold on to that for the moment. And we are just waiting to see what happens as far as some type of a bigger picture data collection. But that is really the big thing that we're focused on, that we know we need numbers. We know we need information and outcome information.
Amazing. Thank you so much.
Diane?
Yeah, the question, Lori, and just really, really impressed, but I also know how cannabis regulation kind of helped build up this infrastructure. But is there, now that the process has begun, is there anything that the state or you in particular are thinking about that you would approach differently in hindsight? I think data is the biggest issue that we have here. Public safety data in particular is no one can really qualify. Is there a problem with the illicit market? Is there not? So anything you guys would have done differently or upfront for the working group of things we need to be looking at to ask in our report?
Well, it's definitely the money and making sure that you have the money for staff. That has been something that has been discussed over the last year. Do we have enough funding for staff? Do we need to transfer the cost of this program? I mean, DORA is that licenses are the sole way that the program is funded, through licenses. So this is extremely challenging at the onset because we do not have accurate numbers of for sure how many people will apply. We had a low number of training programs and we far exceeded that, thank goodness. But it is all a lot of unknown. And so possibly maybe some surveying could be helpful. I know that the Department of Revenue set out a survey for their healing center licenses as they were working early on to try to collect some information. So I would say I would recommend that as early as possible to try to get an idea of the interest. It will really support you in fee setting and knowing the costs and the amount of staff and so forth you needed. We started in Colorado, we've started very small with licensing. It was me and one other person, and we've just added a few people throughout the year to keep the cost really low. Of course, the clarity surrounding the data collection, that of course that is the biggest piece I think that was missed early on. And then we were very concerned about having the actual approval or the authority to approve the training programs because that's usually done through education departments. So I would say look at that really early and make sure that any kind of education or training that there actually is the correct authority early on in place to do that, because that needs to happen first before you can actually, provide licenses to anyone. There needs to be a lot of training and education. And we also we don't have any money really for our educational aspect. So I would say, look for ways to fund that to create awareness. There is a lot of confusion in the community about what's allowed through the bona fide religious and harm reduction and spiritual allowances versus whether or not they should come into the regulated market. I feel strongly that those who will be the individuals seeking natural medicine services will want their medicine to be regulated. They will want that. However, it's gone on for a very long time in the community without that happening. So I would focus some time and energy in that regard also.
Dr. Shad for a second.
Yeah, I just had a question, and you may have already addressed this, so I'm sorry if I missed it, but is there any recommendation in the rules and regulations about what kind of dosages? Are we only going to use micro dosages or the trip dosages?
There is dosages in and we have two. So we have two dosages. I mean, we have a maximum dosage, which is set now, but they are going to discuss microdosing. So dosaging is ongoing. We have it probably every other month. We talk about dosages. Are they correct? What information is there? Do we need to expand? What needs to be done? And right now, the advisory board has been fairly reserved in comparison even to Oregon in the dosage. And, we're developing a form to help facilitators who are not clinicians work trying to determine what it looks like for dosing. So for safety, for doing risk analysis and background and so forth when they're doing their preparation to determine that. But it is also sort of challenging because there's not a lot of great data out there. I mean, it's developing and we're looking at it, but it's
Yeah, I'm sorry. I think there is some data. There is a study comparing even a clinical trial in which psilocybin has been compared with the Lexapro or escitalopram, and there are many other studies which actually the micro dosages are coming out very safe. For example, 10 milligram or 25 milligram, and beyond that, I don't see much kind of data on higher dosages. So there are data. The other question. Yeah.
Excuse me, one of the concerns with microdosing is observational data. It's not
I'm
placebo
sorry.
controlled.
I don't want to debate with our presenter today. So, I mean, we've talked about that in previous meetings. So if there are no other questions, then I want to thank you, Lori, for your presentation today. And we will move on to our next presenter, Kate Cotter.
Thank you so much.
Thank you. I will share my screen here. This is different than looks like I may need permission to share my screen. Can you do that, Marla?
Well, let me see.
Thank you.
Frame. I am not seeing a way to do that. So I'm happy to share it for you. You just emailed it to me.
I did. Yeah, thank you.
Yeah, I'm not seeing a way to do that. So hold on.
I may be able to do it on this side, but it looks like I have to quit and reopen. So maybe I'll do that while you're pulling it up. Oh, you got it. Perfect. Okay. So as Marla said, we are doing an overview of the federal and state codes and regulations. Can proceed. Essentially, there were a number of drug laws that were consolidated under Comprehensive Drug Abuse Prevention and Control Act of 1970. Can proceed. And underneath this act is Title II, which is the Controlled Substance Act of 1970. And this created the legal framework that regulates the manufacture, distribution, and use of controlled substances. And it's also worth noting, in regard to psychedelics, there were about 3 decades of research prior to 1970. And at this point, the research stopped for approximately almost another 30 years. Okay, can continue. So technically, the Controlled Substance Act, CSA, is Title 21 of the United States Code. It specifically is Chapter 13, 21 United States Code, Section 801 and following. And I have the links on the slides that Marla can share with the group. Okay. So there are 2 key components to the Controlled Substance Act. One is the drug schedules, and one is the enforcement and regulation. You can go ahead. There are key sections of the CSA, and in the interest of time, we won't go through all of these, but for the record, Section 812 covers the schedules of the controlled substances. 823 is the registration requirements around research. 841 is the Prohibited Acts A, which covers the penalties for intent to distribute and also for simple possession. Section 846 is attempt and conspiracy. 847, Attorney General's authority. And 952, import and export of controlled substances. Continue. So with the CSA, it outlines 4 schedules, and these are based on the potential for abuse, medical value, and the degree of dependence that the substance may carry. And Schedule 1, as we know, says that there is a high potential for abuse, no accepted medical value, and a lack of accepted safety, even under medical supervision. Go ahead. Most psychedelics are Schedule 1, and under Section 812, it outlines psychedelics that include LSD, marijuana and THC, and the derivatives, psilocybin and psilocin, MDMA, mescaline, NN-DMT, 5-MeO-DMT, peyote, and ibogaine. And then under Section 823, we have the registration requirements around research. Essentially, researchers are required to get a DEA license to study. Proceed. And then this also outlines the pathway for the scientific research. Continue. And then in Section 841, we have Prohibited Acts A. This is outlining the penalties for illegally manufacturing, distributing, and dispensing of controlled substances. And these penalties are based on the schedule and the amount involved. So under Prohibited Acts A, we have the first offense for Schedule 1 or 2 substances, 10 years to life in prison. If death or serious injury is involved, 20 years to life, and up to 10 million for individuals, 50 million for entities. And then you'll see that the second offense is 20 years to life, a minimum of life if death or serious injury is involved, and fines up to 20 million for individuals, 75 million for entities. And then in section 844, we have first offense, and this is for simple possession, imprisonment up to a year, fines minimum of 1,000, maybe additional consequences. Second offense is minimum 15 days up to 2 years, $2,500 minimum, maybe additional consequences. And third offense is imprisonment or with a mandatory minimum 90 days and up to 3 years, minimum $5,000. So in regard to the enforcement and the regulation, the DEA works with the FDA. This makes sure that the scheduling is based on scientific evidence along with the enforcement considerations. And then the DEA is responsible for, it's the primary enforcement agency, and they are responsible for the scheduling, the rescheduling, and the enforcing. And they also regulate the manufacture, distribution, and dispensing of the controlled substances. And the FDA is responsible for scientific and medical evaluation of the substances. They provide the recommendations to the DEA based on medical use, safety, and abuse potential. And then for the process of rescheduling, there's 2 ways you can go about this, either through legislation, Congress can directly change the scheduling, or a petition can be submitted by either the DEA, Health and Human Services, or a third party, such as a researcher, pharmaceutical company, or an advocacy group. And then if you are rescheduling by a petition, there's a process involved where an initiate petition is submitted. The FDA conducts what's called an 8-factor analysis, where they assess the abuse potential, medical use, and safety. And then the FDA submits its findings to the Health and Human Services, which then makes a recommendation to the DEA. The DEA reviews the recommendation, takes public comment, and then they make a final decision. And if they decide to reschedule, they'll initiate what's called a rulemaking process. And this is linked on the slide for more information, which will publish a proposed rule, and then it will reopen a public comment period. And then after considering those comments, the DEA will issue their final rule on the rescheduling of the drug. Now for the Nevada state codes and regulations, we have our codes are codified in the NRS chapter 453. This is our primary legal framework for psychedelics, which are Schedule 1, as we talked about. Our system is very similar to the federal system. We have 1 through 5, and this is codified in NRS 453-166. So within the code, with possession for intent to distribute, NRS 453-337, for Schedule 1 or 2 substances, we have Category D felony for the first offense, 1 to 4 years in prison and fines up to $5,000. I think there might be, can you proceed on the slide? Would you scroll down? There you go. Second offense, Category C felony, 1 to 5 years, $20,000, or third or subsequent is Category B felony, 3 to 15 years, fines up to $20,000. For simple possession, which is codified 453-336, the first offense is Category E felony, 1 to 4 years in prison with possibility of probation. Second offense is Category D, 1 to 4, and $5,000 in fines. And third or subsequent is Category C, 1 to 5 years in prison, up to $10,000 in fines. And in regard to religious use, which is codified 453-541, Nevada is very similar to federal in that we allow the religious use of peyote by members of the Native American Church. And then in regard to research, Nevada is very stringent also. There's really no way to study a Schedule I substance without a DEA license, and there are only a few of these. 2 of them are held by doctors Dustin and Rochelle Hines, who are doing work at their lab at UNLV. Important to the discussion around federal and state codes pertains to the categories of drug policy reform and how that might be relevant for potentially changing the laws in Nevada. So we'll briefly cover these and where we are now, and you can proceed, Marla. The first category is research, which is essentially SB 242. This working group is an example of that, where there are stakeholder groups. Sometimes funding is allocated, sometimes not. It's essentially to study the policy reform efforts in other states and the therapeutic potential of psychedelics. At least 10 states now have passed study groups. The second level is deprioritization. This is referred to as lowest law enforcement priority. And you may be familiar with the decriminalized nature initiatives that have passed in 24 cities and 2 counties. And this has quote unquote decriminalized entheogenic plants and fungi, but it technically hasn't changed the laws. It's just made it the lowest law enforcement priority. Then additionally, the third category, you can scroll up. Sometimes some of these cities have also placed limits on enforcement funding. So perhaps if the mayor and or the city council have set the budget, they may not allocate funding to enforce certain laws. And then the fourth category is called defelonization. And this is where it simply takes the penalties and reduces them from a felony to a less serious crime, such as a misdemeanor. And New Jersey is a perfect example of this. They defelonized psilocybin statewide. And then the fifth category is decriminalization proper, which actually does change the law. It reduces the penalties to an offense that is not considered a criminal offense. It might be a civil fine or infraction, but it's still illegal technically. And then the sixth level would be legalization of cultivation and sharing. And this is often referred to as the grow, gather, give model. And as we heard in Lori's presentation, part of Colorado's Natural Medicine Health Act actually allows adults to use, possess, and cultivate the non-synthetic, the natural compounds, as long as it's non-transactional. And then the seventh level is legalization of supervised consumption. And this is where it would relate to the Oregon and Colorado regulated access models for supervised administration of psychedelic substances. And this usually involves licensing with the cultivation, licensing for manufacturers, for the laboratories, and most certainly for the facilitators. And then lastly would be legalization of a regulated market, full legalization. And this would be akin to alcohol or cannabis, where there might be age restrictions, but you could essentially walk in off the street and buy the substance. So as you can see, we are currently in Nevada at the first level with the research, and our conversation has largely been centered around the possibility of reducing penalties and looking into what would be considered the legalized access under supervision model like Oregon and Colorado. So that wraps the presentation, and thank you for your time and attention.
Thanks so much, Kate. Appreciate it. Diane? I'm sorry, Diane, go ahead. While you're having your figuring it out, we'll go with Dr. Shad.
Yeah, I have a question, and this is a little bit out of the probably context here, but I just wanted to ask you that, ketamine is also considered as a psychedelic by a lot of people, right? Is there any regulation against ketamine?
So ketamine is Schedule 3, and it's It is considered by many a psychedelic, but it's not a classic psychedelic. It's a dissociative anesthetic, as I'm sure you know. And so when we're talking about rescheduling or reducing penalties for Schedule 1, we would probably not be considering ketamine.
Yeah, the reason I asked that question is because ketamine, like PCP, high dosages can cause schizophrenia-like state, and can be really problematic, and some people really have a very kind of psychotic, agitated, aggressive behavior with it. And so I wonder sometimes that when we create these rules and regulations, do we consider all these things?
Well, and it's interesting that you bring that up because ketamine, which does carry an abuse potential and can be very helpful for a lot of people for acute suicidality and is shorter acting, but is actually considered by many more dangerous than some of these entheogens, which are now still Schedule 1. And that's why this is such an important conversation to be having.
Thank you. Diane, did we get you back?
Yeah, I logged out and logged into another laptop. Can you guys hear me?
We can.
Okay, so this is really more of a comment. First of all, Kate, great presentation. I think these are all really important things that we're going to need to discuss in the report is, you know, in part of the action plan. But the comment that I wanted to make is that the federal government does not fund research that promotes the legalization or the efficacy of any drug or other substance included in Schedule 1. And this goes back to 1996, and it's really critically important for this working group to understand why we're still in kind of this vicious cycle relative to the issues of research and efficacy. And so it you know, part of the work that we do is we have to address the gaps and why we're at this place. You know, so I think about all our policy should be based on the sanctity of life. Schedule 1 was political and not based on science.
Thank you, Diane. Excellent point.
Dr. Hines?
Yeah, and just to further that, you know, systems are complex and big, and I'm not defending the system that Diane was just talking about. I'm kind of part of it. And I was just on a part of an FDA board saying, look, we screwed up here. We can't work these compounds in the normal ways. How can we fast track them? So you can just see the system's broken, and these do offer immediate relief for many of the problems we have. So thank you for your presentation.
Terry?
Yeah, thank you for that presentation. It was very helpful. And this is probably more of a comment than a question. And just looking kind of at the devil's advocate component of this is in looking at some of the systems and laws that we put in place for cannabis legalization. I feel like one of the things we really missed out on, which I think Washington State did a good job, is really knowing some of the, if you will, downstream effects. So for example, looking at impaired driving. And I don't know if any of the other states have really looked at this. You know, I know we don't have great data in our state on what impaired driving looks like. So for example, and I'll defer to Joshua, he knows this much better than I, but we look at alcohol. If alcohol is the contributing factor, we don't look at other drugs. You know, then we look at start going down the list. So you know, I would propose to not just with this, but also cannabis, that we start looking at some of those downward effects and what impaired driving, for example, does look like in our state. Thank you.
I think that's really important. And as Lori was mentioning too, if we are able to put into potential legislation to have research for outcomes like that. And I would also point back to the importance of the Denver report that Brian Lang spoke about, where they did a report after a year of decriminalizing psilocybin when they did that in Denver in 2019, and they found no increase in arrests or hospitalizations or adverse events, which is very promising. So I think it would be really important to collect that data and see if that seems to be true across the board.
Josh?
Hey, thank you again for that presentation. It was great. Just a couple things I would add to some of your laws. The weights of the laws, the breakdown of basically your schedule 1 and 2, and then your 3, 4, and 5 of how much the weight and the crime associated with that. And then also the trafficking weight too as well, because I think that's important. From a law enforcement perspective, we in our section, we're going after our traffickers, which, would be 100 grams or more. So I think, and that's a lot of psychedelic drugs, the psilocybin and the MDMA stuff that we're seeing on the street. So that was the only thing I would say to add to that, is just break down the weights for the legislation to review that, so they see the significance of, what just straight PCS is or what trafficking is, so you could see the difference in the crimes and who the people that we're actually going after.
Absolutely. Thank you. I was on the fence about whether to get super granular about it for time's sake, but since you're a subject matter expert, I will take that to heart and include that. Thank you.
Thank you, Josh. Appreciate that.
Thank you. If there are no other questions, then we will go to, I think I want to, if there's anybody on the public that wants to comment briefly about this presentation, I would open up the floor for you to do that. Anything else in the public that you wanted to offer specifically about this presentation? Okay, not hearing anything, then we'll go to item 7. And so, as you all know, the legislation that enacted the subcommittee or enacted the working group has a provision that requires the working group to develop a strategic, measurable, and actionable plan allowing access to safe and affordable entheogens so that such entheogens may be used for therapeutic purposes. And so I included that in the initial draft of the draft report. So that's kind of how we're working this in. But Senator Nguyen, did you have a comment?
Oh, I'm sorry. I was premature. I'm going to let you finish talking.
Okay. All right. So, well, we have the opportunity to either kind of work through what I started on page 6 of the report, or we can consider in whole item 8 and the draft report itself, and get your thoughts on how to proceed with both of those items. Senator Nguyen.
Okay, now I think I'm ready. My recommendation is I'm looking at this report and I'm seeing and hearing some of the significant conversations that we had just today that are not included in that report, specifically any of the information around Colorado, which I think when you only really have two when you only have like 2 places to really look at, if we don't include one of them, I think that's probably problematic. I think it doesn't accurately reflect the work. And so when I saw that, and granted, I know that Marla, you have so much on your plate, and in addition to this, you have your regular job. And so I was looking at some other examples of reports that we produced for the legislature or other organizations and things like this. And one of I think a good example that we could look at is a report that was provided by the Cannabis Advisory Commission. That's something that I can put in the chat and I can provide to everyone as a part of this group. But I think that kind of gives us something to consider and gives us a more like framework to construct this report around. I know that Marla, you have the ability within the structure of this to designate a subcommittee to finalize this report, to include some of the information that was incorporated today, as well as, just making sure that the report is comprehensive. I agree with, I think it was Mark who said during the minutes, we want to make sure that all the information is included in there, even if we disagree with it, our members disagree with it, but we also want to make sure that it's accurate and it includes every aspect of the conversation. And I feel like the report as it is right now doesn't necessarily have all of that information, and that has nothing to do with you, Marla. I think it's just a huge project. But if you would be open to it and the committee would be open to it, I think designating a subcommittee to finalize that report and having a brief meeting where we're able to do that before we finally submit that to the legislative body, I think would be helpful. I don't know if you have any ideas of who would be included on that, but I would leave that to, you know, this committee or Marla, if you have any ideas about who would be on that, I'd be happy to lend my resources, but I think obviously I don't think everyone has the time, and it's probably not effective to have everyone that's on this committee be on the subcommittee. So I'll just leave that up to you, but that's kind of my comments, suggestions, and opinions on the matter right now.
Thank you. I appreciate that. And because the legislation does specifically give the chair that authority, I don't think it's something that and it's not on the agenda, so we couldn't vote on it anyway. But I think given the makeup of the committee and the fact that we don't want to get into basically a violation of the open meeting law by having everybody serve on it, if I'm thinking 3 or 4 people, potentially John Dalton, Dustin Hines, potentially Mark McBride, and then yourself, Senator Wynn, or Assemblyman Carter, if you're open to that. And then that way, again, we do have to post an agenda, and it would be subject to the open meeting law in terms of debate of the report that gets recommended up to the final group. And we would participate in that in terms of developing the agenda for that committee and staffing it. But I think the vision is that kind of starting with this very basic outline, building on that piece of it from the information provided in the committee. And I would encourage you all to limit your information to what was provided during these committee discussions. And then if you're comfortable, you know, and then outlining other areas where we may have been deficient in moving things forward in that final report for consideration by the legislature. So Assemblyman Carter, do you have thoughts?
Well, yeah, I'm not comfortable with this draft report in any way, shape, or form. It's not following the intent, or I see the plain language of the legislation. We were supposed to do a deep dive into all of the contributing factors and then come out with an actionable plan. The actionable plan here is not a plan at all. And one big thing is we're supposed to be dealing with entheogens. Why is ketamine even mentioned in here? Ketamine is not an entheogen. Ketamine was not within the scope of this piece of legislation. And I don't understand why it's in there at all. Plus, all of these facts and figures, you've reiterated constantly that only things that were presented. Well, all of these facts and figures from the Metropolitan Police Department were not presented. We were presented with a story of people getting naked, killing their families, and chasing cops down the street. I don't see that in here. So I've got a big problem with this, and I think that I'm not comfortable with the draft action plan and report at all. And that's my comments.
And again, I appreciate that. And I think we've all acknowledged that it doesn't meet the needs of the working group at this time. And so my position is I'm going to appoint a subcommittee, and I'm looking for a member that I've identified members that I would like to appoint. If you want to serve on that subcommittee, I'm happy to appoint you to it. Otherwise, at this point, I would appoint John Dalton, Dustin Hines, and Mark McBride. Or Senator Wynn, if you want.
I'm happy to serve on it.
Okay.
I'm happy to serve on it.
I will add you.
I can do it as well. If you want 2 legislators, that's fine. If you want 1, that's fine. Whatever you feel more comfortable with.
Well, I think that's a good size group. That would be 1, 2, 3, 4, 5 people. You know, I will just go ahead and do that. So we will not take any action on items 7 or 8 at this point. And then, so that leaves us with the 4th meeting to do the adoption of the report itself that is developed by the subcommittee. So I will poll members for that final meeting date. And is there any other comment with respect to
Yeah,
that?
ma'am, I would also offer up, because Ms. Cotter was, there for the entire community. That was the position that she was in. I would probably recommend that she be on the subcommittee also.
I'm going to respectfully decline that at this point. I think this is a good cross section of the group. And again, everybody on the working group will participate in that last final adoption of it. So from a formal, and the subcommittee itself will be an open meeting. So again, everybody is able to participate from that perspective. But I do want to limit the number. And so
What is the reason for limiting the number? So I understand it doesn't seem like that's a bad thing if we've got, subject matter experts and thought leaders, Nevada thought leaders in the subcommittee.
I just want to remind you all that we are, I developed the work plan way back in the beginning. I asked for participation on the work plan. Tell me what you all wanted to hear. That work plan is what we worked from for this committee. So I don't want the subcommittee to turn into more data gathering, right? The subcommittee should look at the items that were presented during the hearings and develop a final report and the final action plan based on the information that was discussed. And so by limiting that number in a subcommittee, we hold integrity to not violating the open meeting law by having too many people from the committee, making decisions on behalf of the working group. And I do see two hands up. Assemblyman Carter, did you still want to comment?
That was a residue from before. No, I'm good.
Okay.
Thank you, Marla.
All right, and Dr. Hines.
Yeah, Marla, I think you've already kind of assuaged my comments. And I think for me, as a subject matter expert, I brought many, many references to the committee. Even today, what's been brought up, we've discussed, Mark brought up, about microdosing. I've talked about those papers in this committee. So, and again, I think it's above the scope of, what you're trying to do as chair. I can easily on a subcommittee bring all these facts. And I think these facts absolutely need to be in the report. So I'm very grateful that you're making this subcommittee, and I think we do need to populate it with recent references. A lot of the references in the document are very old as far as this field and not at the current state. So that's something I can offer as help.
All right, thank you. So at this time, I am going to move to public comment, our last opportunity for public comment, which to provide public comment telephonically, dial 1-775-321-6111. When prompted to provide the conference ID, enter 172-799-042#. If providing public comment during the Teams meeting, unmute your microphone prior to speaking. Persons making comment will be asked to begin by stating their name for the record and to spell their last name. Is there anybody wanting to make public comments? Okay, I'm not hearing or seeing anything. I want to thank everybody for your time. And like I said, I will poll for a final meeting date for consideration of the final report. And I will work with the subcommittee members to develop an agenda and for that meeting to consider the draft report. So thank you all so much. And we are adjourned.
Thank you, Marla.
Thank you.
Thank you very much.
Thank you.